for webcasting, training purposes and for the purpose of keeping historical records and making those records available to the public. Can I now ask everyone to introduce themselves who will be taking part, starting with the applicants.
Good afternoon, sir. My name is Simon Herriott, Director of Planning with Savills, acting on behalf of the applicant.
Thanks, sir. Marcus Trinnick, King's Counsel, representing the applicant, but Mr Herriott will be doing most of the talking.
Thank you. And for the council?
So, it's James Finlay, King's Counsel. To my left sits Roderick Dull. I can't anticipate who's going to do the most talking, but we both may contribute.
Okay, thank you. And Mr Kelly?
Thank you, sir. Ian Kelly Planning Consultants Limited, representing Mr and Mrs Crook. Thank you.
Okay, thank you all very much for that. The purpose of today is for us to discuss some of the matters raised in the hearing statements relating to legislation and policy. I don't intend to go over ground that is already agreed, or where I do not consider that I need further information in order to prepare my report. The session will be a structured discussion which I will lead based on the circulated agenda. I will not allow any formal presentation of cases or cross-examination. I will lead the discussion on the agenda item by directing a question at one of the parties. After the answer, I will allow others to comment, and this may generate a bit of further discussion or questions. If you have comments or questions as the discussion progresses, please make sure that these go through me and let the other party finish their point. If you want to put your hand up to draw my attention to you, then please feel free to do so. I will leave it up to each lead spokesperson to decide who answers my question. Please have the documents to hand electronically and refer to the document number and electronic page and paragraph number if you're making references. And I would ask if you just give a bit of time, because this download speed is a bit slow. So I was having issues this morning with just keeping up. So if you can just give a pause, that would be helpful. I will keep us moving through the items moving on when I consider that I have what I need to write up my report. Don't feel obliged to comment if you're only repeating what has already been said by someone or it's already included in your submissions. All that you tell me today is evidence that may need to be included in my report, and you will see me taking notes. Again, I may pause from time to time to make sure I have what I need. If required, we can take a break in an appropriate point during proceedings, but I'm hoping we can get through this session fairly promptly. Before we turn to the first main agenda item, does anybody have any procedural questions at this stage? I'm seeing shake of the heads all round. So, turning to the agenda, item 2 on the agenda, which is headed Electricity Act 1989, Schedule 9. Mr Herriott, in his hearing statement at paragraph 5.2.3, which is electronic page 17, states that reasons for objection refer to Schedule 9 of the Electricity Act, but it is probable that this specific part of the Electricity Act is what the Council is referring to. And I think that's just in the reasons for objection, almost the preamble part to it. Just clarify with the Council that that's the actual part is being referred to.
Yes, yes.
I think it just doesn't say it, but I think it implies that that's the section that it's referring to. Yep. Okay. Right, thank you. Okay. So, secondly, under item B, status of the applicant. Again, following on from this question, Mr Herriott highlights at paragraph 5.2.6, same page, in this hearing statement, that the applicant does not currently hold a generation licence, and therefore statutory duties set out in paragraph 3 of Schedule 9 to the Electricity Act do not apply to it directly when formulating proposals under section 36. Therefore, Mr Herriott contends at paragraph 5.2.7 that as there are no statutory tests or duties for them to accord with, and the introductory aspects of the Council's reasons for objection should be dismissed as irrelevant. Can the Council respond to that contention, and if it considers that there are any implications for its position, in relation to its reasons for objection?
Perhaps I can, as it's on the floor. I accept the point being made that the duties don't specifically apply to the applicant, but they are, my understanding is that I think they do apply to the decision maker. So they're not irrelevant for that purpose, but I accept the point that Mr. Harriot's made that they're not relevant to the applicant isn't subject to the duty, but you are, so they are relevant for that reason. But hopefully that clarifies that point.
That would be my understanding. I don't know whether Mr. Harriot has any other comment to make on that.
Yes, I would agree with that.
Agree with that? Mr. Kelly, if you want to say anything, please do shout in case I don't. Okay, thank you.
It is, and can I pick up a further point you made this morning on the references to viewpoints 10 and 12 in reason 1 for refusal? It may just be an appropriate time to do so. They're referred to twice in reason 1. The first reference is clearly incorrect because it's in a list of ostensibly significant impacts about which there's dispute, but viewpoints 10 and 12 should not be in that list. The second reference is not incorrect, but the context for that can be found, I think it's paragraph 7178. It's a, just double check that. Well, sorry, I'm in the report of handling, which is 426. I've got the wrong reference. Yes, sorry, 7.148, which is electronic page. Starts on electronic page 49 and goes over to electronic page 50. And the point that's been made is that it's an example of a deviation from the clustered approach to wind farms. So it's not suggested there's a significant effect, but it's that's the context to which that reference refers. And reading the report as a whole with the reason for objection, that is also consistent with what's said in the annex which deals with the viewpoints. So there's no suggestion of a significant impact from there. It's the point of clustering that it's relevant.
Thank you for that. Does the applicant have any comment to make on that? Are they happy with that explanation?
Given we didn't raise that word under the point of the floor, so I'm happy to accept both those points, sir.
Sorry, on the point of flora, that's taken out as incorrect, and on viewpoints 10 and 12, it's referenced that it's not significant, but it's referred to in a wider context. Okay. Okay, moving on to item 3, which is in reference to the updated energy and legislation policy position. Mr. Dowell, in his hearing statement at paragraph 7.1, electronic page 13, states that he does not consider there to be any major policy conflicts between the parties that the reporter must resolve in order to determine the current application. This position, I think, is generally reflected in the statement of agreed matters between the applicant and the council. However, Mr Herriot, in section 4 of his statement, pages 13 to 15, highlights that there has been some further developments in legislation and policy since the applicant's policy and energy policy statement was submitted at the end of 2023, and he then makes reference to the Climate Change Scotland Act 2024, United Nations Emissions Gap Report 24, Clean Power 2030 Action Plan, Programme for Government 2025-26, Building the Best Future for Scotland. Mr Dowell also refers to paragraph 5. Also refers that paragraph 5.12, his electronic page 12, in his hearing statement to the onshore wind sector deal for Scotland, September 2023. So there's a reasonable raft of other documentation there. My question to parties is, do you consider that there are any changes in these more recent documents that need to be taken into account in my assessment of the proposed development? So I'll just start with the applicant.
Yeah, I'll just deal with these in sequential order. The Climate Change Reduction Act from 2024, that's the key legislative change, and that moves the greenhouse gas reduction targets from an annual basis to 5-yearly carbon budgets. The first one being between 2026 and 2030, and that was ultimately in response to a Committee on Climate Change report, which said that the Scottish Government's previous target of a 75% reduction in emissions by 2030 was out of reach. Now, the net zero target by 2045 still stands. It's the pathway and the measurement tools to get there that have changed from an annual basis to 5-yearly budgets. So that's the key change in that regard. But to say that the net zero aspiration for 2045 still stands.
So do you consider that changes any of the position in terms of the proposed development?
It means that ultimately, I suppose, ministers and decision makers are not having to look at these on an annual basis. There's a budget that's there, which it's binding. It's a duty upon ministers to achieve that ultimately. And we do get annual and indeed quarterly updates on emissions. For example, the latest emissions that came out have shown a 51.3% reduction relative to the first budget period. So it's just showing the state of progress or lack of, and ultimately what needs to be done.
But to reach the same end goal?
Correct.
Right.
Yeah.
Okay, thank you. We'll just pick these one at a time just so that, for the Council, any comments on this?
I think for all the documents referenced there, I think the overall comments from Highland Council would be that these don't change the test of NPF4 for ourselves. NPF4 is a relatively recent document in itself, and I don't think any of the documents referenced in this section tip the material balance any further than is already covered elsewhere. So I think that would apply to each one of these documents.
Right, so that's the first 4 documents plus the onshore wind sector deal you're referring to?
Yeah, that'd be correct. I mean, I can, if you want to work through them, can maybe give a bit more commentary on the onshore.
If you're saying to me that there's no significant change that, in terms of sort of national policy direction, that is critical for me to take into account, then I'm happy to cut to the chase if that's. I don't want to go through each one laboriously to end up with the same position. So if you're happy to rest on that,
that would be the Council's position, yeah.
Okay, Mr Kelly.
Yes, sir, I would support the Council in relation to all 5 documents. They provide context, but they don't really change any of the key tests that you will apply to answer the question, the right development in the right place. The only thing I would add in is there is some uncertainty in relation to document 3. If you look at the documents I submitted, 015-003 is the UK Grid Boundary Constraints Plan, and 015-005 is the Clean Power Action Plan capacity caps, which sets technology and geographic limits on what should be accepted into the grid. I don't think the actual appeal decision was submitted. It was very recent, but one of your colleagues dealing with a battery energy storage system at Spittal quite rightly recognised what these documents were saying, but described them as guidance rather than policy. So we'll have to wait and see how that pans out. But basically my position is one of supporting the Council in relation to all 5 documents. There's nothing else to add.
Okay, thank you for that. Everybody else just jumped to the chase, Mr. Head. Do you want to go through each one, or do you want to summarise your position?
I think maybe I'd just like to summarise the position with regards to the Clean Power 2030 document, which is 008017, because that cuts across a number of the points we have on the agenda relating to grid and constraint payments, and I'll try and make what is a complex and evolving picture fairly simple. Historically, grid connections for generation projects have progressed on a first-come, first-served basis. That is effectively moving now to a first-ready, first-connected model. So the further a developer is down the line with the consenting process and land, the more likely NESO considers that they will be ready to connect into the system and distribute electricity. Culachy Windfarm has been through the Gate 1 process, and it has been through the first part of the Gate 2 process, and it's received confirmation from NESO that it is what NESO would now term strategically aligned with CP30. NESO has not made a firm grid connection offer to the developer at this point in time because the planning process is still rumbling on. But when a decision is made on this project, and if consent is granted, that will be the next trigger. And at that point, they will be able to confirm a grid connection offer. So the idea is to remove, let's call them zombie projects, from the queue that have got no realistic prospect of coming forward in housing parlance to be an effective project. So I think that's the key point from CP30.
Okay, any other points from any other documents that I should be aware of in my considerations?
No, just to reiterate that the onshore wind sector deal, which is 008010, which is referenced in the Council's hearing statement, deals with a number of issues, but ultimately the key objective there is to deliver on the collective ambition for 20 gigawatts of onshore wind by 2030, and that's actually 12 gigawatts of new installed capacity from where we stand right now.
Okay, thank you for that. Following on from that then, in terms of some of the draft documentation, I think Mr Kelly did mention that there was guidance, and we'll wait and see. In terms of the weight to be given to these documents, is there any comment that anybody wants to make? Mr Harriott?
I think the context to your decision, the weight that you need to give to the benefits of this project in achieving those targets is significant, as set out in MPF4, and it is an evolving picture. So they contribute to the wider picture of progress, what still needs to be done, what's going on the generation side, what's going on the grid connection side. But the weight that you give to the potential contribution of this project to those legally binding targets is one that's set out in policy, and that's significant weight.
Okay, thank you. The Council?
In general terms, no dispute with that, and I preface this comment by a target is not a cap, and there are various targets, but you might like to note that in maybe a condition that was referred to later, condition 7, there's the applicants requesting a 7-year commencement period to accommodate a grid connection date of August 2032, which would be then relate to which target this scheme might contribute to. So it might, if it's not connected until 2032, it's obviously not going to contribute to a 2030 target, but it would contribute to a later target. That may have, will have some relevance, but it's, as I say, there's no cap, and there are successive targets going forward. But I just draw that to your attention to complete the picture.
Okay, thank you. Anything else, Mr. Kelly? Okay, thank you. Right, moving on to item 4. This is looking at the Scottish Government's onshore wind policy statement, which I'm sure everybody is quite familiar with, and just the accuracy of the capacity projections in the table on page 5. The guidance recognises the crucial role of onshore wind in achieving renewable energy and greenhouse reduction targets. Climate change in the UK Scottish Government's renewable energy policies are important considerations in the decision-making balance when considering the acceptability of this proposal. The Council and the applicant appear to agree that climate change, energy-related targets should all be afforded weight in the planning balance. I don't think there's any dispute over that. There's also agreement in the Statement of Agreed Matters that the Scottish Government's targets, as expressed in policy documents, do not set any ceiling or cap, which I think is what Mr Finlay has just referred to, either nationally or locally, nationally or for any local authority area. So insofar as the targets concern renewable energy development, references are to installed capacity, not consented capacity. So that's what we've got set out in the SOAM between the Council and the applicant. Mr Kelly, in his hearing statement, at paragraphs 30 to 36, and that's on pages 8 to 11, refers to the need case for the proposal, and I think you've touched on this already, Mr Kelly, and references made to the NESO information, published statistics for Q1 and the Clean Power 2030 Action Plan 2025 update. Those are 0015, 0013 and 015.0015. Mr Kelly concludes in paragraph 32 that there is absolutely no need for any new onshore wind farms to be consented to meet the public interest and satisfy the Government's policy demands of either required future demand for electricity or the securing of a net zero outcome. Therefore, I'd like to just probe a bit more about the projected capacity figures on page 5 of the onshore wind policy statement, and to some of the wider changes which we've touched on sort of already. So just to kind of give this a bit of an airing, firstly, feeding into that, can the applicant confirm what the likely implementation date, which I think, again, Mr Finlay has been preempting some of my questions, would be for the application if consented, and to what extent the project would help to meet the 2030 target? I know Mr Finlay's given a comment on that, but I'd like to hear from the applicant.
Yeah, sure. That is out of the applicant's hands. Ultimately, as I said earlier, the next stage in the process, having gone through Gate 1 and the first part of Gate 2, the next stage in the process for grid connection will rely upon if and when a consent is granted for this project, and at that point the applicant can engage with NESO again with greater certainty on the planning element, and NESO will be in a position to make a grid offer. That grid connection offer could be pre-2030. If it is post-2030, which Mr Finlay's alluded to, my understanding of the process is that the applicant can actually ask for that to be brought forward, for example, if their project is up and ready and has got financial close, conditions have been purified, etc. So at this point, can't give a definitive date for when it would be connected to the grid, or indeed when the grid connection offer would be made, because that's not been forthcoming from NESO just yet. And that's not unique to this project. That's the new process for grid connections.
The second part of that question was, if consented, what extent would the project help to meet the 2030 target? You're saying that really just depends?
It depends what will come forward. I'm just understanding that the projects, the strategic alignment with CP30, which NISO have confirmed this project is strategically aligned, doesn't mean that they need to be up and running and spinning by 2030. That's the understanding, that there's a recognition that the connection beyond 2030 can be constrained. For example, the SSEN who are providing the links, so they would have to provide, for example, a Section 37 application which need to be consented. So there are a number of uncertainties there at this point in time. But what we do know is, anecdotally and through other evidence and discussions with Highland Council, that they and other councils are dealing with a number of connections and overhead lines and Section 37 proposals in direct response to CP30.
Okay, thank you for that. And the council wish to make any sort of further comments on this?
No, I think the only thing was that in the meantime the page 5 figures from speaking to our development plans team, the kind of current capacity has moved on a little bit in the meantime, but it was just to flag that up. I'm just trying to find the figure now that they were mentioning. So they said as, by 1st of June 2025 the figure had increased to 10.3 gigawatts, but other than that, no further comments.
Okay.
Yeah, just to clarify that point, I was going to come on to that as well. The figures we've got in 2022, and this comes back to this issue of the installed figure. So at the time of the onshore wind policy statement, the installed figure was 8.7 gigawatts, and that's in paragraph 1.1.5, which is just above the table. And I think Mr Dowell is referring to the same updated quarterly statistics that the Scottish Government has released. And what we've got there is an installed figure of 10.4 gigawatts as of this summer. So there's been an increase of 1.7 gigawatts, which still leaves a shortfall of circa 9.5 to meet the 20 gigawatt target by 2030.
Mr Kelly, you've obviously, in your statement, explained your position. Is there anything else you want to add to what you've already written or in response to what you've heard?
Nothing, sir. I just wanted to check a factual matter. I was scanning the documents. I couldn't find it. Have you been supplied with the Quarter 2 2025 energy statistics from the Scottish Government, published in September?
Sorry, not that I recall, but with the quantities of documents that have come in, I couldn't say for certain whether they're, but not that I recall, no.
So it's not an issue that the changes are only marginal. That's also, otherwise I've nothing to add. So.
Okay, thank you for that. Okay, item B, again this is a point raised by Mr Kelly, the issue of wind farm constraint payments in paragraph 33, and that's page 33 as well, of the offshore wind policy statement, does highlight rapidly increasing constraint payments. I think that's at paragraph 8.2.2, but does not seem to go as far as to say that they will be reduced. Is there anything further that you want to add to that, Mr Kelly?
Nothing significant, sir, that I feel decision makers need to be aware of this, and they also need to be aware of what's happening with the grid. In that, as I set out in that paragraph, simply building more infrastructure in Scotland will not solve the problems because of the grid constraints further south. So I'm not saying that increasing grid constraints payments mean in itself that no more wind farms should be consented. All I'm saying is that decision makers should be having regard to the consequences of their decisions.
Okay, thank you for that clarification. That's helpful. Do the applicant or the council want to come back and make any comment on that? The applicant?
Yes, sir. Thanks. Yeah, I think the first thing is constraint payments. It's a recognised issue, but it's not unique to onshore wind as a technology. Constraint payments are paid to other technologies as well. the point about granting consents or waiting effectively until the grid's sorted is goes back to the point I made earlier about how CP30 is dealing with an oven-ready project being able to connect earlier. If we were to put the pencils away and not do anything on the generation side and wait until the grid is sorted and we've got new overhead lines, etc., the developer in this case, Fred Olsen, in going to NISO, they would be put to the back of the queue because they don't have the planning consent. So you need to demonstrate progress on land, progress on planning, so that when you do go and ask NISO for a connection, they have got a higher degree of confidence that you've got a viable, deliverable project because the variables have been sorted out. So the consenting process for generation needs to continue rolling along. Otherwise, that person, if they don't have the consent, goes to the back of the queue.
Okay, thank you. From the council?
Yeah, I think just to reiterate what Mr Herriot was saying there, that we're clearly aware of the issue. It gets raised on a regular basis at our committees by elected members. However, I think in this instance the constraints payments issue doesn't affect the assessment of the proposed development from Highland Council's perspective. Grid constraints or otherwise can't be taken into account in the planning assessment of the acceptability of the proposed development. So that'd be our line.
Okay, thank you for that. Moving on to C. This was just a minor point, sort of clarification about the weight that's mentioned to climate emergency and community benefits. Just looking at the interpretation of paragraph 3.6.2 of the onshore wind policy statement, it indicates a stronger weight being given to the contribution to the climate change emergency as well as community benefits. The climate change emergency we're all probably fairly familiar with, but what do parties take to mean by community benefits? So goes to the applicant first.
I wonder if that's a typographical error, sir. Community benefits and their materiality in the planning process is well understood. I wonder if that meant to say something like socio-economic benefits. Supposition on my behalf, but yeah, that's where we are on that point, sir.
Okay. And councillor?
Yes, I mean it's common knowledge that community benefits of themselves, such as the payment, are not relevant material considerations. Socio-economic benefits might be, and we may be having a discussion about a condition to secure those are not in due course. But yeah, there's no disagreement on that. And whether or not it's an error, or whether it wasn't just inexact use of language, I think it's probably.
Thank you. I'll leave that for others to make a conclusion on whether it was an error or not. But it was just a minor point, just to make sure parties were all on the same page. Okay. Moving on to National Planning Framework 4, which is 0010.001 for reference. Parties agree that the proposal, being an onshore electricity generation station with a capacity exceeding 50 megawatts, is a national development, and that it falls within the definition of essential infrastructure. I don't think there's any debate on that matter. There also seems to be general agreement that Policy 11, Energy, is the key topic policy in relation to the proposal, but that other relevant policies within NPF 4 are also to be considered. And I think that's what comes through the Statement of Agreed Matters from parties. Policy 4, however, natural places, there's relevant parts of Policy 4 that apply to the application and interpretation of acceptability. Mr Herriot, in his paragraph 5.3.9 at electronic page 19 of the hearing statement, indicates that the Council's reason for objection 1 does not specify which part of Policy 4 the proposed development is considered to be contrary to. So can the Council just respond to that in terms of what it considers are the relevant parts of NPF 4 Policy 4 that it considers the proposal doesn't accord with?
So 4A and 4D are relevant, but it would be 4D1.
sorry, apologies, I was just trying to get to my copy of NPF 4. So you said policy 4A?
4A and 4D are relevant,
Yeah.
yes.
In terms of 1, just to reiterate what I said first thing this morning, it's the part of 1 which refers to qualities, not integrity, because 1 covers both.
Okay, so part 4A and D are the relevant bit, yes. Although they're not mentioned in the reasons for objection. That's correct, yeah. Okay, and the applicant?
Yeah, I was seeking actually clarification of that. If we just deal with each reason for objection individually, the reason for objection 1 just mentions policy 4 without any subsection. I understand that policy 4D is the referenced in reason for objection 2, and that's why I raised that point in my commentary and went in my hearing statement paragraph 5.3.9, and I went through sections A through to G, and again, speculation on my behalf, but I felt that in terms of the reason for objection 1, it's only policy 4A.
Okay, so your view is 4A and not D?
In terms of reason for objection
yes.
1?
Yeah. Yes. Okay, and is that present? Mr. Kelly, do you have anything to add?
No, sir, nothing to add.
Okay, thank you for that.
Sorry, so there is more to say about 4B.
Yes, I'll come. If you bear with me, I'll come on to that in a minute. Yeah, because we're going to pick up under item B, 4D, looking at part 1. Will your point be covered okay in there? Because I've got one more point to make before we go on to that. If it's not, we'll pick up. So it also. Yeah, also Mr. Herriot's hearing statement at 5.4.6 on page 25. It states that in terms of Part A of Policy 4, it is again contended that the test here is the acceptability of the effects that's the crucial test, not the identification of significant landscape effects. First of all, just check with me, is that what you're intending in the comments in your hearing statement?
Yes, that's correct.
That's a fair summary. Okay. Would the Council like to respond to that?
Yes, the test in 4A is clear. It's one of acceptability.
Thank you. I just want to be sort of clear so that we're all on the same page with when we're looking at the policy position, that I'm looking at it in the way that it's meant to be. I think that's a helpful point. Yes, Mr. Finlay.
It may assist if clearly what makes a development acceptable or unacceptable, and we covered this in part in the landscape and visual section. Just because there are significant effects doesn't make a development unacceptable. But when reason 1 is read in the context of the report as a whole, the reference to the significant effects in the remainder of reason 1 are the reason why the officer concludes ultimately that the proposal should be refused on that reason.
Okay, I think I understand part 4A and the points that are made. If there's nothing else on that, I'll move on to item B, and this is looking at policy 4, natural places, part D 1, and that's the consideration of integrity and engagement of part D2. So again, so I keep referring to your report, Mr. Herriot, but it's the easier way to go into this. At paragraphs 5.4.9 to 5.4.10 on electronic page 27 of Mr. Herriot's report, he states that there's no reference to any consideration of the integrity as it relates to the Loch Ness and Dunshaig. I've never pronounced that properly, so I apologise. To the SLA in the Planning Officer Committee report, and that no evidence has been provided to support any conflict with NPF Policy 4D1, which says the development will not have significant adverse effects on the integrity of the area or the qualities for which it has been identified. As such, as contended by Mr Herriot, that element 2 of Part D is not engaged in this case, as referred to in the Council and its reason in Objection 2. Now, is that a fair summary of your position, Mr Herriot?
It is, yeah.
Okay. Mr Trinick, you wish to come in, I can see.
Maybe now, maybe later, but I just want to amplify that a bit. That in terms of the evidence you've heard in the inquiry session, Mr Daly, Mr Daly, simply said at 6:22 that the dramatic Great Glen SQ quotes will be compromised to an extent. That's the evidence. It's not addressed in the Highland Council hearing statement for this session at all. There's no, indeed, Mr Dowell simply says, I will defer to Mr Daly in terms of the effects. So there's no claim of a breach in the hearing statement, a breach of 4D1 based on the qualities for which the area has been identified. So we're left really with no evidence at all upon which the Council can claim a breach of 4D1, not covered in the report of handling, not addressed in those terms in Mr Daly's inquiry report, not addressed at all in the Council's hearing statement. So that will be the point we've made the submissions, but it's fair to give notice at that point now.
Okay, thank you for that. Would the Council like to respond to that? So really what I'm looking for is clarification of what the position is in relation to Part D of Policy 4 and whether Element 2 should be engaged. We've heard what Mr Trinick said in terms of the evidence, but the Council's response.
Yes, I'm grateful to Mr Trinick for his forewarning, and I can respond to that in submissions. But in terms of Policy D2, on the clear wording of the policy, that only applies in terms of adverse effect on integrity. So if there is an adverse effect on the qualities, then on the face of it, D2 does not apply. Assuming for the moment there is an objection on qualities, significant impact on a special quality, D2 doesn't of itself provide, isn't engaged. I would accept that it's a drafting point, perhaps an unusual point that they're not both covered, but the factors that are referred to in D2 might well be maybe relevant to the overall consideration of the weight that's given to a significant impact on equality. But in terms of the actual policy itself, it says what it says.
Sorry, that's helpful for that clarification. Remind me to turn that on. I keep forgetting to I'll leave it on. Moving on to Policy 11, Part C, Net Economic Impacts. Really, the question to parties is a general one. Just how can it be demonstrated that net economic impacts have been maximised, which is I think a question that's running around quite a lot at the moment. Some concerns have been raised, and this is the reason I'm asking it today, about the experience of wind farm developers in this regard, and I think there's some reference within Mountaineering Scotland's objection, but also Mr Kelly has made a passing reference to that as well. So I would just really like to get parties' views on that. Maybe start with the applicant to say, how would you intend to ensure economic benefits are maximised from this development? Maybe that can start the discussion.
Yeah. Well, in terms of the intention, how those will be delivered, Mr. Finlay referred earlier to a potential condition that has been looked at. That could be, I don't know the specific wording of that, but that could be achieved to secure details of how the socio-economic benefits for this particular project could maximise local benefits, to be submitted and agreed in advance with the council. That's how it potentially could be delivered. In terms of what net economic benefits means, this isn't a new MPF4 phrase actually. I had a look, it's been in existence since the SPP days in paragraph 169, so it's not a new test, and it has been assessed in various decisions with ministers concluding net economic benefits have been delivered or could be secured by a project. So there's no new test set in that particular element of policy 11 that was not already in 169 of SPP.
Okay, thank you for that. Mr Finlay, would you want to end that?
I'd need to check, but my recollection is that the word maximise wasn't in 169 of SPP, and it's so I think there is a new test, and again, Highland Council don't take a unrealistic view. When applications come in like this, which have started before MPF4, and there's no guidance as to how you demonstrate maximising net economic benefit, you have to have a realistic approach to it. And the local condition that Mr Herriot was alluding to is something that may be debated later in the condition session, but that's certainly one method of securing net economic local benefit and community socio-economic benefits such as employment. But in general terms, because the application is not put together with, as my understanding anyway, with the aim of demonstrating maximising net economic benefit as opposed to demonstrating net economic benefit, it places the applicants at somewhat of a disadvantage in pure policy terms. But previous reporters have looked at it in the round, and whilst technically it may be said that this application doesn't demonstrate maximisation, it does demonstrate economic benefit, and it's the securing of that. So it's not a point that Highland Council place any significant weight on against the development, provided the benefits that are provided are properly secured.
Okay. Thank you. Mr Kelly, do you have anything to add? So there was a point that you had highlighted.
Thank you, sir. In fairness to the applicants, I would say that it's actually presented in NPF4 as quite a stark policy test. It says proposals will only be supported where they maximise net economic impact. But again, trying to be fair, I'm sure the person who wrote that probably didn't understand that at the application stage there's only a limited amount that the applicant can actually commit to at that stage in terms of contract awards, etc., what they would spend money on. So in terms of the test, it's actually very hard for the applicant to pass it at this stage. But I prefer to think of it as bad drafting, and perhaps really it should be interpreted that the applicant should set out their intentions as to how to maximise impact. So I would not ask that you fail the applicant on this test despite the stark wording. So.
Okay, I won't redraft National Planning Framework 4 as in the context of this application, but it's just to hear the points. Mr Channing, did you want to add something there?
Mr Finney is quite right about SPP 2014. It did not have the word maximise. I'm grateful to Mr Kerr. It's a very generous approach to take. It's a very difficult test to prove you've passed. I prefer to phrase it in terms of has the applicant demonstrably done the best it can at this stage to demonstrate that it will bring proper economic and social and environmental benefits. This is as far as we can go at this stage.
Okay, thank you for that. I just wanted to hear that just to get...
So perhaps I could just add to that. In terms of application, does it, if this was a development plan test, does it accord with the development plan or MPF4? In strict terms, the applicant probably fails under 4C. But when you look at policy, sorry, 11C, if you look at policy 11 overall, if otherwise it would comply, it's still going to comply with policy 11, notwithstanding it doesn't tick the box under 4C.
Okay, that's helpful, thank you. Moving on to 11D, and the relevance of this part of the policy to local landscape designations. We're going to Mr Herriot's report in paragraph 5.4.14, that's on page 16. In that, he highlights that the reason for objection 2 makes reference to the proposal not according with Part D of Policy 11. Part D states that development proposals that impact on international or national designations will be assessed in relation to Policy 4. The Statement of Agreed Matters on Landscape and Visual states in paragraph 5.21, that's electronic page 9, that parties agree that no international or national landscape designations would be significantly affected by the proposed development. So we just welcome if the Council could clarify its position in relation to the application of Policy 11D for the proposal.
It only applies to international and national designations.
Yes, so that's quite clear, and there's none of those that affect the current application.
No.
Okay. Mr Hayes, do you want to add anything to that?
I think that clarifies my query. Reason for objection 2 does specifically reference policy 4, and it says at D. And that obviously just engages international and national designations, so I was just a bit confused about that. But that's
So just to be clear, it doesn't apply in this instance, and that's the basis I will sort of progress on because of the lack of designation. Okay. Moving to... Sorry, Mr Finlay.
My apologies, it's just something I wanted to pick up. I think that, my apologies, I see, yes, the references to 11D and E, and that reference is clearly an error for 11D. Whereas 4D is not an error, 11D is an error. We're discovering more errors in this reason for objection as we go through. Yeah. And I don't think anywhere in the report is it suggested that 11D would be engaged.
No, that's part of the reason why I was asking, because going through the reasons for objection, there was just an inconsistency. Okay. Moving on to 11E. We're going to Mr Herriot's report at paragraph 5.3.11, and that's electronic page 20, where he indicates that having regard to the Officers' Committee report in terms of the reasons for objection and considering the absence of objections from key consultees on other topic areas, it is assumed that the Council is referring solely to Part E2 of Policy 11, which deals with the landscape and visual matters in its reasons for objection. So again, it's just asking the Council for its view on that matter on the application of 11E.
Yeah, that would be correct. It would be 11E2, which requires the proposed development, project design, mitigation to demonstrate how the following impacts are addressed. But that's not to say that the other elements of 11, play into your overall balance and exercise, but not necessarily a reason for objection in their own right.
So, just to be clear, it's focused on 11E2. Okay. The applicant want to make any comment on that?
just to clarify that in terms of the reference to policy 11, in reason for objection 1, the only criteria, the only point where the Council's got a fault is in relation to E2. That's this Council stated position, because I wasn't clear. because there are a number of elements of policy 11 that decision makers need to engage with. I just wasn't clear at what particular aspect the council's finding fault with in RFO1. But if it's E2, that's clarified, and that's the only part. So no issues with any other parts of the policy.
I'm assuming the council is focusing that it's the landscape and visual impacts are the basis for the objection.
Yeah, that's correct.
Yeah. Okay. Okay, moving on to item F, which is policy 11E, the definition of localised and design mitigation. The applicant contends in the statement of agreed matters for landscape and visual effects at paragraph 510 and 516. That's on pages 6 and 7 of the statement of agreed matters, that significant effects on landscape character and visual receptors will be contained within a localised area around the site and immediate landscape and visual context that surrounds it. And we've kind of rehearsed a bit of that already in the landscape and visual inquiry session. The council, however, contends that significant adverse landscape and visual effects would extend further than found in the LVIA, including significant adverse effects from viewpoints and to visual receptors west of Loch Ness, which again we've kind of rehearsed and looked at this morning. Really my question, which is one that's been discussed on several inquiries I'm sure, is what do parties consider to be the localised effects, and when do the effects extend beyond what could be defined or accepted, reasonably accepted as localised? So it's a big question, but I don't want to repeat the stuff we've gone over already in the last day and a half, but it's just looking at that point of, you know, what is the extent of localised, because there's obviously two different views on that matter. So if we start with the applicant.
Yeah, I think the term localised, I think any reasonable reading of that or understanding of it must start with a consideration of the geographical extent of the effects. And once the geographical extent has been established, it's to consider the nature and sensitivity of receptors potentially subject to significant effects, whether that's landscape designations, individual viewpoints and their associated sensitivity. So in this case, as we heard it in the landscape and visual inquiry session, there's a dispute about what we would consider to be localised effects and what the council may consider to be localised effects. I think the key point from our perspective in policy terms is that we take that away. We've got no issues with the integrity of the SLA. We've got no issues with any national scenic area. There are no issues with any national park, and we don't have a wildland issue. So while those designations may experience some visual effects, there's no objection on that point we've heard earlier about the integrity point on the SLA. There are significant visual effects, and they were discussed earlier today, and my reference to other statements and other decisions on what has been considered localised by other decision makers is referenced in my hearing statement. And what we're saying here is that we have got a constrained and localised ZTV for this project, and that's recognised by the council's landscape architect. And what we're saying is that the spread of localised effects for this scheme is actually aligned with and probably closer than has been deemed localised by decision makers, including Scottish ministers on other projects.
Pausing to add, I wasn't sure whether
I was just going to refer you to some other decisions there. Apologies.
That's okay.
If you look at Bunloin, I was just looking at the reference, and that's reference 13035, Glendy 010009, and Darvery 013027. They deal with the localised point and give it a spatial context.
Okay, thank you. And the council?
Yes, my understanding, certainly in terms of what I put to Mr. Welsh, was that we're there's agreement between the parties. It's not just geographical extent that's relevant. There are a number of other factors. I think he quoted the Garvery decision in extenso in his report. The councillor put in the Forsyth decision where the reporter makes the same point. So my understanding, first of all, is that it's not just geographical extent. There are a list of factors which I won't repeat, which are relevant. First point. The second point is that those factors will vary according to the circumstances of each case. So whilst there is some benefit to be gained from looking at other decisions, they are certainly not benchmarks or determinative, because every decision will change. The circumstances will change. Bring that to this case. If and we had perhaps didn't make this clear enough when cross-examining Mr. Welsh, but if our case, Mr. Welsh's case, is that significant landscape and visual impacts are all limited to 5 to 6 kilometres, broadly, my understanding. If that case is accepted, then there is some support, no doubt, for the approach that the impacts are localised. If, however, they were to extend to Neil Ferveney, as he accepted, over 20 kilometres away, they could not be described as localised. There may be a point in between where you're looking at viewpoints 14, 16, 13, 11, and the additional viewpoint. We say they are not localised. We also say there's a significant impact on LCT 22 to 25 and on one other, certainly, special quality of the SLA. I don't think there's a difference in policy terms, as I understand it, in the test to be applied. There may be a difference as to the weight you can give to previous decisions, and then it's the application of that policy which is going to be in dispute between the parties.
Would you like to add anything else, Mr. Harriott?
Just add one other point about what policy E2 says. There's the other issue of design mitigation.
I'm coming on to that. In terms of the localised, Mr. Kelly, do you have anything to add?
Nothing further to add, sir.
Okay, thank you. So,
can I just raise a point that's been brought to my attention, although it may have been taken for granted. The cumulative impacts is separately listed under E. But clearly, cumulative impacts, I had assumed that when we're talking about landscape and visual impacts, everyone's talking about solus impacts and cumulative impacts.
yes.
So that's why we haven't raised 13 as a standalone point, but I don't think there's any need to. But I just wanted to be absolutely clear about that.
Yeah, obviously I'll be looking at all the criteria, because I'll be looking at more than just landscape and visual. So I'll be going through all of them and making my...
I think everyone treats cumulative impacts as part of landscape and visual. And
it's a separate criteria.
Yes, but I just pointing that out. Yeah.
Okay. And moving on to what I was about to be preempted by Mr. Harriott. And what do parties consider is meant by the need to apply appropriate design mitigation?
I'll go first then. So that part of the policy, it's an and or. So what it's talking about is recognising that significant landscape and visual effects are to be expected for some forms of renewals. And it's talking about when those would be likely to be acceptable. And that says when they are localised and or appropriate design mitigation has been applied. And Mr. Welch deals with that much more in his inquiry statement. It was discussed in the inquiry session. But as far as design mitigation goes, his inquiry statement and indeed the EIA report charts the design evolution of the layout of the proposed development, including its location within what he's described as a topographical bowl. So a combination of site location within the topographical bowl and the layout, which responds to other factors, not just landscape and visual. There are other constraints that go into the design equation. We feel that as a result of the design mitigation, effects are localised, and if there's a dispute in that point, but ultimately we also feel they're acceptable in terms of policy E2.
Sorry, can I add to that answering your precise question, I think you apply the mitigation hierarchy. You avoid, then you minimise. And that process has been gone through, we say demonstrably, through the design iterations which are in the EIAR. The second point I make is that the Council take no issue on the design and layout of the project. You'll remember my discussions with Mr Daly on that point. So there's no dispute, I think, between the Council and ourselves about the issue of appropriate design mitigation.
And I take, given that that's under the landscape and visual impacts, it's the design mitigation on those factors. So I think, Mr Hay, you did stray into maybe some of the other site things which are relevant, but for this one.
Agreed.
Yes. Okay. So, Mr Finlay.
Yes. Design can cover everything from choice of location to the specific design of the project. Mr Trinick is entirely correct that both at Culachy 2 and Culachy 1, that the Council's case was not based on the specific design solution, the location having been chosen. So to that extent, what is appropriate design mitigation will relate to the location. Whether there's been this design mitigation is appropriate for this location is, I think, where the issue lies between the parties. And I thought Mr Trinick made an interesting point when he talked about the mitigation hierarchy. We would say this was a case for avoid rather than minimise.
I think I'm clear on that particular point.
The one point at which I would come back is I do not think that appropriate design mitigation relates to location. It relates to mitigating the effects of the chosen scheme.
Okay. And just to be clear, when you said location and layout, that would also include maybe the height of the turbines as well in terms of design mitigation, because that would be another physical factor to do with that. Yeah.
All Mr Daly has said about that, which I think is the point Mr Trinick pointed out this morning, is that if you have higher turbines, the impact might be greater. But that's...
Okay, that's very helpful. Thank you for that. Moving on now to item 6. This is just some minor clarifications to do with Highland-wide local development plan. It's been agreed that this is the LDP of most relevance in this, in consideration to the proposal, and that there are no policies of direct relevance in the Inner Murray Firth local development plan. Can I just check with the council, is that's the position that I think has come to?
Yep, that's correct.
Okay, and the applicants agree with that. Okay, so item A under this is to do with policy 67, and that I think is in para 5.3.23 onwards, in page 21-22. Really, what I'm just trying to establish whether parties are in agreement that policy 67 is the key local development plan policy in the consideration of renewable projects such as the current proposal. So just start with the council.
That's correct, yeah.
Yep. So any disagreement from?
No disagreement.
No. Mr Kelly, are you comfortable with that?
Yes, sir, but given the age of the local development plan, I tend not to refer to it in evidence as such.
I'll make no comment on that. Yeah, this is a follow-up question for the council. You make reference to that in the reasons for objection. Are there specific, if I can get that word out, specific parts of this policy that the council consider the proposal does not accord with? Because I don't think it's clear what particular of the criteria. So it's just to make sure that I'm looking at the right elements of this policy when I'm considering it.
Yeah, no, it's policy 67 includes a kind of broad range of matters similar to those in policy 11E to 1 to 13. I suppose the key one that you're looking at is with regards to landscape and visual.
I've got the policy in front of me here, policy 67. There's a
Yeah,
text
but-
in 2 bullet points, a couple of paragraphs of text, and then another series of
Yeah.
bullet points.
So I'd say bullet point 3, visual impact, and then impact on landscape character.
This is in the second set of bullet points.
For
policy.
67, yep.
Yes.
Yeah, that's correct. So that would be the key one. Onto bullet point 4, amenity at sensitive locations, residential properties, workplaces, and then to various degrees, you know, tourism and recreation interests, second bottom one, and then up the top as well, given potential impacts on Corriaric Pass, General Wades, Military Road.
Sorry, I missed that last
Sorry, I was saying bullet point number 1 as well, natural art and cultural heritage features as well, just given the historic features in the wider surrounding area.
And,
So
and are these the bullet points that would form the basis for your reason for objection then? Or matters to be considered in my consideration of the proposal?
yeah, as part of your balance, yeah.
Perhaps I can.
Yeah.
Yeah, they are matters, they are relevant parts of the policy for you to consider.
Yes.
Our objection is visual impact and impact on landscape character, and we're not taking a cultural heritage objection. We're not taking a economic impact, tourism impact objection, but within landscape and visual, there is an element of our objection which touches on impact on the Wade Road and the Corriaric Pass, and impact on tourists when they're at, for instance, top of Meal Ferveny. So it is primarily the third bullet point, but subject to that explanation.
Yeah. Clearly, I'll be looking at the policy in the whole, but it was just to find out what specific elements that form the reason for the objection.
Yeah, apologies if that wasn't clear.
No, that's
bullet,
okay.
bullet point 3 is the key one, but then
Okay.
the rest is James said.
And Mr. Herrick, do you have anything to add to that?
No, just grateful for that clarification. I was just slightly concerned when we mentioned the first bullet point restrained the cultural heritage issues, but RFO1 does say at the top of the page is detrimental visual impact. So,
Yes.
yeah. So
Yeah. So some of these are just for my clarification,
Yeah, sure.
so that I'm 100% clear. I've got the accurate case from both sides. Turning to policy 8, sustainable design, again, just for clarification, just so the council can confirm, this is not a specific renewable energy policy.
Sorry, I
It's
missed
not
that.
a
Which one?
specific policy 28.
28, no.
It's not
Sustainable design, no.
So can you just expand on the parts of this policy the proposal doesn't accord with, and how this policy should maybe be applied in light of the policy changes with NPF 4 and the onshore wind policy statement?
So I think just the principle of policy 28, it supports the right development in the right place at the right time. So therefore, the council will support proposals where it's satisfied, you know, they're located, sited, and designed such as they will not be detrimental overall, either individually or cumulatively with other developments. And again, that's reinforced by what we've covered previously when assessed against the relevant criteria noted in policy 67.
So is it fair for me to take it that this is a general policy that applies to all development types?
That'd be correct,
and
yeah.
you're specifically looking at it in the context of a wind farm, but it's a general policy.
That's
That'd
correct.
be fair?
Yeah.
Okay. Okay, just in terms of the Highland Local Development Plan, then just parties review in summary other positions with the overall compatibility of the relevant policies of the LDP with NPF 4. Are there any issues that parties have with that? Mr. Herrick?
I think The LDP is now, what, 13 years old, so it predates the MPF4 by 10 years. So it's a document of its time, and it can't be expected to reflect current national planning policy. As regards renewables, we've got Policy 67, which the criteria largely align with Policy E. The key change is what we do with all those criteria and the project benefits. So we've now got the very clear direction in Policy 11 of MPF4 that those benefits should be given significant weight in the planning balance. Those words and that direction does not apply in Policy 67 of the Highland-wide plan. It does still require you to look at project in the round, but what you do with those benefits was a discretionary matter previously, whereas now it's not. So that's the key change in that policy between that and MPF4.
Okay, thank you. Councillor?
In broad terms, we say it's consistent. It's a positive policy supporting renewable energy, subject to a balancing exercise. The terminology is obviously older. There are elements in the Highland Wide Local Development Plan, such as the treatment of wildland, which are out of date. But leaving that aside, you should get the same answer applying Policy 67 as you do Policy 11, to which means there is no lack of accordance, and that's the way other reporters have approached it.
Okay.
Yes, it is a positive policy, and it can be applied in the up-to-date policy context perfectly adequately.
Okay, thank you for that. Item 7, we're looking at the onshore wind energy supplementary guidance that we've been going through at some length and some detail for the last day and a half. But I suppose my simple question, Mr. Herriot, at para 5.3.49, electronic page 25, and this is where he states there's a disconnect between the council expects developers to achieve through the criteria of the supplementary guidance. That's at para 4.16, following pages 20 to 22, and what is now stated in NPF for Policy 11. Policy 11 recognised that, and I think this is a point you may have made, that significant landscape and visual impacts have to be expected for some forms of renewable energy, and by expecting developers to avoid significant landscape and visual effects, there's an element of inconsistency between supplementary guidance and NPF 4. So my question, maybe start with the council, is how should the criteria of the guidance be applied in the light of NPF 4 Policy 11 and the OWSP really impacts, sorry, the expectation of the impacts on the landscape? Mr. Finlay?
Well, in general terms, the criterion are there as, they're not there as policy tests and never have been. So they are factors to consider which should help illustrate the decision-making process. And whilst the expectation that there may be an expectation that the criteria are there to assist both applicants in putting forward their application and decision makers, but they are not policy tests. They are factors to take into account. I don't think anyone's disputed the relevance of the factors. How you judge the result of application of those factors is another issue. So in our submission, there's no inconsistency with Policy 11. And the fact that the expectation that there will always be significant landscape and visual impacts, whilst it's expressly recognised in MPF4, was a fact of life long before MPF4, that there will be significant landscape and visual impacts from any commercial scale wind farm. It was not a new factor raised by MPF4 or identified by MPF4, but it has been expressly identified in MPF4. So again, in our submission, that doesn't make a difference in the application of the criteria. There's no fundamental inconsistency between that recognition in MPF4 and the position beforehand and the context in which these criteria were developed. And I would say, just by way of background, Highland Council has been approving wind farm proposals which clearly have significant impacts for some throughout the life of wind farms, so that context is well understood.
Okay, thank you for that. Do you want to add anything to?
Yeah, I think that the use of the word expectation and what we now in the OWSG in paragraph 4.17 and what we've now got in MPF4, that there is a jar in there, as Mr Finlay says, it's what you do in the judgment point. If the start of your journey is that you expect applicants to site design proposals to avoid significant effects, and we've got a situation at the moment where the council has found non-compliance with those 10 criteria, what do you do with that in the planning balance? What do you do with that in the judgment? To me, what the OWSG says in that particular point is very different from what we've got in MPF4, where there's a recognition that significant effects will arise. On the one hand, recognising it, whereas the OWSG has got an expectation that they will be avoided. So I think that's down, I agree with Mr Finlay, is what the decision maker does in that judgment point, and I would defer to the MPF4 on that.
Okay, so I think as Mr Finlay said, it is guidance, and I guess if guidance is looking to avoid something, then it's not saying that it's going against it completely, it's just that it's almost like a mitigation hierarchy to avoid in the first instance. So you may well not avoid it, but the test is still NPF4, policy 11, is the actual policy test. Yep. Okay. Anybody else anything to add to that? No? Okay. My computer has just frozen on me. Bear with me a second. Well, I go old school because I've got a paper copy of what. Okay, apologies for this, but this. No, as we say, Houston, we have a problem. Right, bear with me. So, other matters under item 8. Looking at the first one, there's reference being made to undoing previous mitigation and safeguarding of areas within which the application is located. Again, referring to Mr Herriot's submission at para 5.3.50 on page 25, he highlights that in the concluding final sentence of reason for objection 1, the council states that the proposed development will undo previously secured mitigation associated with nearby wind farms. In addition, Mr Herriot 5.3.54 on the same page states that in the Officer Committee report the term safeguard is used at several points to describe efforts to resist wind energy development in this area, until I retain views south down the Glen, Annex 5 assessment criteria 6, or that the proposed development would increase the spread of wind turbines into an area that has previously been safeguarded from turbines. That's paragraph 7.134 of the report of handling. So just in that context, can the council just sort of clarify whether there's a specific LDB policy or piece of planning guidance that forms the basis for or sets out the approach to seeking to safeguard particular areas, including the appeal site from development of wind turbines, and was that the basis of the previously secured mitigation and how it was arrived at?
So in terms of the point about previous mitigation, it's Highland Council's view that newer wind energy schemes should not undo the mitigation secured by other wind energy schemes. And with regards to the safeguarding point, the idea of safeguarding important features and assets within the Highland area, it's also well established in Highland Council policy and guidance.
Can I just, in terms of when you say the policy guidance, what documents are you referring to?
So in
that's what I couldn't.
Okay,
I couldn't establish where the basis for, normally if it's safeguarding, you might have a spatial strategy, for example, that identifies areas that are safeguarded. And I think maybe in the previous spatial framework, there's maps showing areas, Area 1, Area 2, Area 3, as you had with SPP, you had spatial frameworks.
Yeah.
I wasn't sure whether it's a hangover from that, or whether there's a separate document that you can refer to that talks about seeking that mitigation or the safeguarding.
So there's a couple of paragraphs in the onshore wind energy supplementary guidance that's explicit about safeguarding and making reference to that. So paragraph 4.1, that section sets out how important features and assets identified in Highland-wide local development plan are expected to be safeguarded in relation to onshore wind energy development. And then it goes on in paragraph 4.4 of the onshore wind energy supplementary guidance when it says Highland-wide local development plan sets out specific expectations for safeguarding important natural environmental features, some of which relate to the high-quality landscapes of Highland, and it goes on to kind of expand on that point. So there's a couple of mentions within the supplementary guidance.
Okay, so there's no policy basis for it, it's more a guidance basis. Yeah. Is that correct? It's just I just want to make sure I'm not missing out a policy that actually requires that, because that's obviously a stronger matter that I have to think when you're using those terms than the guidance.
No, I confirm there's no safeguarding policy as such upon which we're relying. The discussion of that in terms of there is discussion of safeguarding in a looser sense, not in the sense that Mr. Herriot's describing it in the guidance for the Loch Ness area. And indeed, I think Mr. Welsh referred yesterday to the idea that you try to ensure there's no visibility or significant visibility from the body of Loch Ness itself. That's the concept that's being engaged here, rather than a specific safeguarding policy.
Okay. And in terms of the sort of undoing sort of previous mitigation, that's in the context of the approval of certain applications in certain locations then, rather than a sort of policy-driven basis?
Yes.
Okay.
Absolutely. It's again the fact that it's another way of looking at what Mr. Daly was talking about this morning of wind farms being set back appropriate distance, for instance, on the east side of the loch, and which Highland Council looks at as mitigation of their impact.
Okay.
But it's not a specific policy test.
No. Okay, I think I understand that now. Mr. Herriot, do you want to add anything to that?
Yeah, I do. I was struggling to find that any sort of policy basis for this undoing previous mitigation, not sure. But I actually found some reference to it in paragraph 5.34 of the OWESG, which is reference 011.
Sorry, what was that paragraph number again?
5.34.
5.34.
And this is a summary of the findings of the landscape and visual appraisal. Now, I do take issue with it, but nevertheless it talks about the study identifies that any remaining capacity for this scale of development should be focused around existing clusters that are generally found in rolling uplands, rugged massif, rocky moorland landscape character types, but only where these are well designed, integrated with existing pattern development, and do not undo landscape and visual mitigation agreed for existing schemes. I'm assuming that's where that comes from. So, to me, that paragraph is very, very deliberately talking about where you're looking at extensions to existing schemes, because that's what it's saying. There's no capacity for new schemes, there's capacity for extensions. And when you're considering those extensions, you must have regard to what impact they may or may not have on mitigation for a previous scheme. So, for example, if a consented and built scheme started life at 20 turbines and was whittled down and 10 were built, and an application came in for an extension to that within the same red line boundary or the same land holding, I think it would be legitimate to look at, you're looking at an extension here, would this extension undo the mitigation previously secured for that scheme? Applying that theory and that logic to a new standalone scheme, as we have with Culachy, separated physically by several kilometres from other schemes, I think that's trying to shoehorn that in, and I just don't agree with that approach at all.
Okay, thank you for that. I think I've got enough. My understanding has been clarified of the policy basis for that, so that's helpful. Looking at item B, and this goes to the relevance of the appeal decision that we've covered in some detail for the previous Culachy Windfarm by my colleague Mr Seaton. Mr Herry, in his section 3 of paragraph 3.15, that's page 12, contends that whilst the 2018 decision is a relevant aspect of the planning history of the site, the proposed development is a different scheme comprising a different number and scale of turbines set in a changed baseline and is to be considered within a vastly different and is considered within a vastly different, and I've got a full stop there, so I don't know what comes after that. I think that's the way it's worded.
Yes, that was the summary. So
Yes, yeah. So my question is, what is the view of parties on the contention that the National Planning and Energy Policy context is vastly different to that of the 2018 decision, and therefore what weight should I give to that previous decision? So I'll start with Mr Finlay.
Well, it's quite clear, for reasons that Mr Herriot's articulated and common sense, that the policy situation has significantly changed. And there are elements of the previous decision which are no longer relevant factors or as relevant factors before you, such as wildland. So but there are, so in terms of the overall decision, it is part of the planning history, and you give such weight to it as is appropriate, bearing in mind those changes. But that's on a, if you like, a global view. There are elements of, there are judgments within the decision, some of which both parties rely on, because you'll recall in Mr Welsh's evidence, he drew attention to some aspects of Mr Seaton's decision that he prayed in aid of his case. The particular judgments that are made are matters for you to have regard to. I would say in particular on the extent of broadly speaking, landscape and visual impacts. If you are to disagree with Mr Seaton, say, at whether there's a significant impact at viewpoint 13 Burak or Mille Ferveny, given the underlying approach of consistency of decision making, then one would expect reasons why you disagree, but you're certainly not bound by, in any sense, by his decision or his findings. But they are factors that you can have regard to, and not only the fact that Mr Seaton potentially reached a view, but whether the view at that particular viewpoint was in dispute previously or not. They are all relevant factors for you to take into account. So you're certainly not bound by his process. They are relevant judgments. Some of the judgments will be more relevant than others. If you were to disagree with Mr Seaton on what is clearly a relevant judgment, then my understanding would be, as a matter of courtesy, if not proper giving of reasons, some indication of your justification for that would be required. But it may well be evident in what you're finding in any event. So I'm certainly not holding that in terrorem over you. It's a classic situation where one reporter is quite free to disagree with another one, and they regularly do. And usually the reasoning is quite apparent from their reasoning in any event.
Okay, thank you for that. Mr Herriot?
Yeah, I agree with much with what Mr Finlay has said. You're not bound by the previous decision. It's clearly a factual part of the planning history, but I think the tangible shift in national policy with his both planning and energy that's taken place in the interim is a key consideration. It certainly was a key consideration for the previous reporter. The previous application was actually a planning application, so section 25 of the Act was engaged, and therefore in paragraph 146 of his decision, the previous reporter concluded there was nothing that required him to give any increased weight to the renewable energy benefits of the scheme in the planning balance. And as I've set out in my hearing statement and bullet point 3.8, that has now evidently changed with MPF4 policy 11, and we now have to give those benefits significant weight, whereas previously he didn't. And sitting alongside that, we have the onshore wind policy statement, which recognises that the move to a net zero economy is going to change the landscape. And I think it's telling and deliberate that the phrase "this will change the landscape" by talking about taller turbines, and that's paragraph 3.6.1 of the onshore wind policy statement. That's deliberately underlined, it's deliberately in italics. That's not a coincidence. And that's a material change I would suggest that should be factored into the decision as well.
Okay,
Just to add to that, so that I agree with Mr. Finlay. In fact, probably say with more firmness that if, as we hope you will, you disagree with Mr. Seaton and grant consent of the project, you do need to give reasons why you disagree with them. To the extent you make, you give views which are contrary to his. That's safety first.
Thank you for that advice. Mr. Kelly, do you have anything you want to add?
No, I have nothing to add to what's been said, sir. Thank you.
Okay, thank you. Sorry, Mr. Finlay.
I was just going to pick up on what Mr. Harriott was saying, that I don't think there's any disagreement in terms of the overall judgment. The policy playing field has been redrafted in respect of individual judgments. There may be relevance in them, and you have to have regard as to whether the extent of change in the policy playing field leads to a different conclusion to that reached by Mr. Seaton, that this wasn't an appropriate place for a wind farm.
Okay. Thank you all for that. Moving on to just item C, which was grid connection. This was a matter raised in Mr. Kelly's statement at paragraph 17. That was page 5. Where he states that the grid connection is not part of the current proposal, even although it is clearly and intrinsically part of the overall scheme. The failure to assess its impact as part of the environmental information assessment means that the whole project has not been assessed in accordance with the requirements of the Electricity Act Electricity Regulations 2017. That's 013.005 is the reference. Mr. Kelly, do you want to say anything more about that point?
I've nothing really to add at this stage, sir, except to say that in the context of a planning application and an appeal, the issue of whether the grid connection should be assessed alongside the wind farm is going before the Court of Session in early December.
So is this is a wider point of principle rather
Yes,
than specific to this application?
Yes.
Right. Okay.
And otherwise, I have nothing to add in relation to this application.
Yeah, because your grid connection would be a Section 37 separate application at the moment.
Yes.
Yes. Yeah.
And it would be the same for the planning application case.
Right. Okay. Does anybody have anything else to add to that?
I'll cover the point of submissions if I need to do so. There is lots of case law on this already, and I'll bring those into play.
Yeah. Mr. Finlay?
There is a case heading to the Court of Session at the moment about whether grid connection is part of the same project. But given the Biodiversity line pretty well runs through the project, it may be that grid connection in this case is not going to be a particular issue. So it's not a legal issue that I'm going to be making submissions on in terms of this project.
I wouldn't want to attach bulldog clips to a 400 kV line, thank you very much.
No, but
I will leave that for another reporter to deal with.
But it may arise in other projects. But I just wanted to make that clear, because Highland Council is, I don't want Highland Council to be saying, or be recorded as saying that they are not part of the same project. In our view, in many cases they will be part of the same project, so it should be subject to the EIA at the same time as the power station. But that will be determined for us by the inner house sometime probably next year.
Okay, thank you for that update. Moving on to item D, which is to do with battery energy storage facility and relevant policy guidance and advice. Again, this is a point raised by Mr Kelly at paragraph 21 on page 6. So, Mr Kelly, do you want to, rather than read out everything you've written down, do you want to kind of highlight the point that you wish to make?
Thank you, sir. Basically, we are in a regulatory vacuum in relation to this type of development, which does raise risks. I refer you to the document I lodged, document 15.004, the Nature Scot response in relation to the Altan Tour, section 36, Windfarm. I don't think it's a matter that you can resolve in relation to this actual application, and to recognise, as Nature Scot says, that we don't have a clear regulatory framework for assessing the risks. And just as an aside, sir, I should say that in other forms of development I have worked with, petrochemicals, nuclear, defence, I have been used to seeing quantitative risk assessments undertaken for developments, but that is currently not a requirement for battery energy storage. So I just want to draw your attention to that Nature Scot response, sir, which I think reinforces the point I've made, that there is no proper regulatory framework.
Okay, that's very helpful. Does anybody else want to sort of comment on that, Mr Harriott? No. Mr Findlay or Mr Dow?
Just a quick one. In terms of, on the agenda topic, relevant policy guidance and council advice, there is battery energy storage facility guidance that's currently being drafted by the Scottish Government, that's been circulated for comment to Highland Council. So hopefully within the near future we'll have some further guidance that we can rely on for these type of developments.
Okay. Yeah, Mr Kelly also did raise, and this might be a crossover here, at paragraph that the Council is actively preparing new guidance on safety issues associated with best proposals. Is that the reference that you're making?
That's correct. We're currently in a situation at the moment for applications, whether it's BESS or associated BESS in this instance, where the Scottish Fire and Rescue Service don't currently respond to individual planning applications, so we're kind of relying on National Fire Chiefs Council general guidance at the moment. But yeah, hopefully into the short to medium term we'll have some further guidance that will give us.
But there's nothing you just at the moment from your refer to. And just on a final point, because again Mr Kelly just raised this, I just want to clarify. He made reference to an interactive Highland Council energy map, paragraph 45 E12. I don't know if you can provide any update on that.
That should be up and running and available to view, just accessible to the public, that shows current and consented energy, renewable energy schemes across the Highland region.
So it's just a factual sort of database of information?
That's correct.
But
yeah.
it's not been presented by the Council in evidence?
No.
No. Okay. Mr Kelly, do you have anything else on that?
Not really, sir. It's a live database that can change every day, so it's very hard to see how you could present it in evidence other than referring you to the website on the Highland Council webpage. But otherwise, nothing to add to that, sir.
Okay, that's fine. That takes us on to item 9, which is really just to see whether there are any other relevant matters that we haven't discussed in this session, or issues that people want to raise before we close this session. Start with the applicant.
None from me, thanks, sir.
Okay, thank you. And the council?
No. None from us.
Okay, Mr Kelly?
No, thank you, sir. Nothing else.
Okay, well, that allows me to bring this session to a close, which is 10 to 3, so we're doing quite well sort of time-wise. So that will end the hearing on legislation and policy. So I would just like to thank you all for your very helpful and positive contributions, and we kept the discussion going at a good pace, but I think I got out of that what I required. We now will need to take a break to see if I can get my computer to actually work, because the screen's frozen on it. It's now 10 to 3. I will need probably about at least 15-20 minutes, I think, realistically. Quarter past 3? Do you know what it is? It's because my screen's... I'm looking at the clock there. My apologies. Think technology has looked at. So it's now quarter past 3. We need 15 minutes to change over for the... What about if we say 25 to 4? Or do you want to... I'll take views. Mr.
Just a bit longer, just to get a bit of prep. Say quarter to 4.
Well, I'm happy with that.
Yeah,
if you feel that gives you enough time, quarter to 4?
Yeah, I think so.
Yes, and I think we're well placed to finish by 5 or thereabouts,
Yes.
so that would be sensible.
Okay, I will take quarter to 4. Okay, thank you all very much. Thank you.